This is Attorney Christopher Ripley. I am an attorney with CCSK Law. Let's talk about Hipaa just for a few minutes. So what is Hipaa? Hipaa is the Federal Health Insurance Portability and Accountability Act. Now, in practice, this statute affects Hoosiers in really two essential ways. And those are how third parties can access your private medical information and how that private medical information can then be distributed to third parties. Now, we want to bear in mind, what protected medical information is, and primarily that's going to be the contents of your medical record, and then who covered entities are, and those are going to be primarily medical providers. So, this isn't necessarily, family members or, issues out on the public square about, potential medical status or health status or what's going on Facebook. This is primarily about an individual's relationship with their physician and hospital and other caregivers. And so primarily we see these issues arise as it relates to access to medical records relating to capacity, and particularly whether or not a power of attorney has taken, has risen into effect. Now, a power of attorney is a document by which an individual can designate an agent called an attorney in fact to act on their behalf. Some powers of attorney are what we call springing, which means that the powers in that document emerge at a later date. And the most common springing trigger is the disability of the principal. So somebody signs a power of attorney and they say, I'm going to do all my stuff on my own unless and until I'm determined to be incapacitated, and then this person has the authority to act for me. Now, that determination of incapacity is normally done by a physician. In order for the physician to then talk to that designated agent, that attorney in fact, or other family members, there needs to be a Hipaa release or a Hipaa-related provision in the power of attorney, or even a separate Hipaa authorization. What these documents do is they say, all right, physician, medical provider, you are authorized to talk with this designated individual and, disclose to them my medical status and my medical records. And in that situation, the purpose of that would be to evaluate the principal for their medical status and, whether or not they're incapacitated, so that the designated agent can know whether or not they're allowed to act. Ultimately, that agent may need to get a statement from the doctor determining whether or not the principal is incapacitated, because they may need to, say, for example, take that power of attorney in that letter to, say, a bank to start managing bills and account transactions, or handle other situations. Now, again, that's going to be, principally a matter of disclosure of one's, personal information as part of fulfilling the goals of your estate plan. We otherwise run into Hipaa when there have been disclosures that may have not been authorized by the principal. This comes up every once in a while when there are collection actions for medical bills, but frankly, medical providers are pretty good about this, and it's fairly rare. If we're dealing with that in other contexts, such as if somebody's medical situation becomes an issue in a court case, that's less a matter of Hipaa, and it's more a matter of the rules of access to court records, which are procedural rules in the state of Indiana that restrict certain sensitive materials from entering the public record. But that may also implicate Hipaa authorizations as well. And so if there is say a personal injury case, medical providers may require authorizations before they start handing out medical records as part of that litigation. But primarily, kind of tying everything up with a bow, Hipaa exists to protect you and your medical information from disclosure to third parties by your doctors, unless there is an authorization or a statutory exception or a designated need for it. If you'd like more information or have any questions, please don't hesitate to contact us at CCSK Law, 57 Michigan Avenue, Suite 101, here in Valparaiso, Indiana, 46383, or give us a call at 219-230-3600 on the website at ccskallaw.com.